Hello and good day to everyone. My name is SIVARANJINI, daughter of RAVICHANDRAN. Today I'll be explaining to you all about Introduction to the Maxim, Equity Acts in Personam. The concept of equity is divided into 12 equitable principles, which is known as Maxims of equity. The principle of equity arose from the liberal application of justice principles with the goal of correcting common law flaws, and in the process of equitable maxims were developed. The Court of Equity usually enforces its decree in personam. The court orders and decrees of the Court of Equity are usually the defendant's nature of personal command and through his personal obedience. The legal rights are not directly transferred to the defendant from the plaintiff. If he does not obey the order of the Court of Equity, he is arrested and imprisoned. The maxim broadly serves the purposes of avoiding a clash of jurisdiction with courts of common law and their procedure, primarily because the procedure of the Court of Common Law operated in rem on the subject matter in dispute and by applying the principles of fair justice and honesty, which directs the individual to comply with the court's promises and directions.
The law of equity was established in the 13th century. At the time, the courts brought to short of claims that were considered as well as the methods by which such claims would be heard. The scope of claims heard grew very strict. The procedure of bringing a case became more complicated, and jurors were often briefed. Legitimate petitioners were regularly denied relief as a consequence of this event. To correct this inconsistency, a remedy may be acquired by petitioning the king, who retained judicial authority over such issues. The monarch charged to allocate to the chancellor the role of dealing with such requests. At the time, the chancellor was frequently a cleric and contentious to the monarch. Until the late 15th century, when the Lord Chancellor's judicial powers were fully acknowledged, the Lord Chancellor gradually developed into a judicial body known as the Court of Chancery. The Court of Chancery was established as a concise court to rectify shortcomings in the common law system. Equity requirements varied from chancellor to chancellor until the end of the 16th century. As equity grew in scope, equally with common law, litigants often used equity to seek equitable injunction to prevent the implementation of common law judgments. The perpetrator may be imprisoned if a common law decision is carried out in violation of an ordinary injunction. In the Earl of Oxford case, the Court of Chancery issued a sweeping injunction against the execution of a common law order. When the two courts were unable to reach an agreement, the matters were sent to Sir Francis Bacon, the Attorney General. Sir Francis upheld the general injunction, noting that, in the event of any conflict between the common law and the law of equity, equity would prevail. By the 17th century, only lawyers were chosen for the position of Chancellor. By the early 19th century, the Court of Chancery had evolved into an equity court. As Sir Francis expressed it, the primacy of equity was finally formalized in Section 35 of Judicature Act 1573, which consolidated equity and common law courts into a single entity known as the Supreme Court. The Supreme Court is divided into two branches, the High Court and the Court of Appeal. The most important aspect of this reform is that each court now has the ability and obligation to rule on issues based on common law and equity principles. This principle is expressed in Section 49 of the Supreme Court Act 1981, which provides that in the event of a conflict between equity and common law, equity must prevail. The rules of equity and the rules of law continue to be distinct, but both systems are now governed by the same court. Prior to the introduction of equity into the legal system, people wishing to dispose of their property in trust faced the challenge of passing title to the specific beneficiary without really giving up the property. Passing property to the trustee could only be viewed as transferring absolute ownership to the trustee, with no consideration for the beneficiary concerns under the common law system. The trust system is built on equity, with trustees holding property in trust for the beneficiary. Equity provides a beneficial interest for the beneficiaries to guarantee that complete ownership to the property vests in them when they reach the maturity as stated in the trust instrument, enabling the trustee to invest or deal with any property whose title transferred to them under a common law judgment. The most crucial concept for trustees to realize is that, although they have the authority to invest or sell trust property, they do it on behalf of the beneficiaries. Trustees that make poor investment decisions violate the trust and are often held liable to reimburse the beneficiaries for any losses suffered as a consequence of their conduct. In this situation, equity normally works in favor of the receivers. Although there is a clear convergence between common law and equity, there are differences in how common and equitable remedies are implemented. Common law remedies are required, but equitable remedies are discretionary and provide at the court discretion. Equitable remedies may be influenced by the conduct and status of the person seeking the remedy. Because the court has the power to analyze the conduct of the party seeking equitable relief, it may decide not to offer it if it believes that their behavior renders it unavailable to them. Certain equity maxims have been formed in such circumstances to aid courts in reaching fair rulings. Equity acts in personam. According to one of its maxims, the defendant is personally subject to the law of equity. There is no issue to the property being outside the jurisdiction as long as the defendant is inside the jurisdiction. The case of Penn and Lord Baltimore exemplified this. Penn and Lord Baltimore entered into an agreement fixing the boundary of the true provision as the treaty in America, Pennsylvania and Maryland, where the former belonged to the plaintiff and the latter to the defendant, under the various grants mentioned in the agreement. The plaintiff sued the defendant in the English Court of Chancery for specific performance of the agreement, and one of the objections raised by the defendant was the question of the jurisdiction of the court, but this objection was overruled by Lord Horwitz, where he said that The conscience of the party was bound by this agreement, and being within the jurisdiction of this court, which acts in personam, the court may properly decree it as an agreement. An order of particular performance was issued to the plaintiff, in this case, who took a boundary dispute lawsuit to an English court, despite the facts that the property was in Maryland, USA. The disputants were both English and resides in England. The maxim expresses the notion of separating between the Court of Chancery's process and the decisions, which originally means its sanctions, the chancellor acting directly on person as opposed to property, or, as the expression goes, on the conscience of persons, was traditionally the pride of the chancery and the horror of the law judges. This in personam concept has its own restriction in that the defendant must be within the court's jurisdiction. The order must not be contradictory to the norms of law of another country, and the order must be capable of being executed without the participation of a foreign court.
The introduction into Malaysian law. Malaysian law is primarily founded on the common law legal system, which means that English law is incorporated into Malaysian law. The applicability of English equitable principles in Malaysia is subject to Section 3 of the Civil Law Act 1950, which provides a cut-off date of 7 April 1956 for West Malaysia and 1st December 1951 for Sabah and 12 December 1949 for Sarawak. It should be noted that Section 3, Clause 1, Clause A refers to the application of the common law of England and the rules of equity, whereas Section 3, Clause 1, B and C refer to the application of the common law of England and the rules of equity, together with the statutes of general application in Sabah and Sarawak. Section 3, Clause 1, on the other hand, states that the common law rules of equity and statutes of general application shall be applied to the extent that the circumstances of the states of Malaysia permit and subject to such qualifications as local circumstances require. As a result, only the parts of English law and equity principles applicable to the local circumstances will be applied. English law will be applied only in the absence of local statutes on the specific subjects, as the former is only intended to fill gaps and lacuna in the local system. Nonetheless, equity principles have long been applied as being in accordance with natural justice principles even before the Civil Law Act 1956. Equity, which means fairness, is a set of rules developed in the late 15th century by the Lord Chancellor and the Old Court of Chancery. Unlike the common law, equity is not a complete set of rules that can exist on its own. It merely filled gaps in the common law and softened the strict rules of the common law. Furthermore, equity is a discretionary justice system, and equitable remedy is not available by default. It may be denied if the plaintiff is deemed morally unworthy. Compulsory wrong in the case of Eastern Properties in Berhad against Hampstead Corporations in Berhad 2007 said it is beyond argument that equitable doctrines are not to be dealt with in a rigid fashion. They are by definition flexible and intended to be applied in such a way that they produce a just result based on the facts and circumstances of a given case. Maxims are used as a rule of thumb and are accepted as established principles in common law. In the case of HUEY case Berhad in liquidation and another against Overseas Credit Finance in Berhad and another's 1988, it is stated that the Malaysian torrent system does not prevent or restrict the creation of beneficial interest in a land. It does not abandon equity principles, but rather modifies the application of specific equity rules to achieve its specific objective. Prior to the registration to title land, where there is a right in personam or an equitable right, the equitable principles of remedies may be applied. However, upon registration of the transfer of the said land to the purchaser, who thus obtains right in rem or a real right in the property, the express of provisions of the National Land Code take precedence over equitable principles. The equitable doctrine of equitable fraud is not applicable under the code provisions. When a valid binding contract for the sale of land exists, right in personam, and there is registration in rem, National Land Code applied and equity is excluded.
Hello everyone, my name is CHONG HIENG, matrix number 066567. I will be talking about the application of the Maxim Equity Acts in Personam in Malaysia. The Maxim Equity Acts in Personam may be found in civil proceedings, the majority of which are land law disputes. It is necessary to differentiate between the exercise of in personam jurisdiction and the exercise of in rem jurisdiction. If there is a legitimate binding contract of the sale of land, the purchaser gains right in personam after performing his half of the bargain. In the case of HIEng and others versus CHONG 1980, it is said that the torrent system is intended to give clarity and certainty in property transactions, which it does admirably without depriving equity of the capacity to exercise its in personam jurisdiction on moral grounds. Hence, it was held that the intervention of equity by a remedy in personam based on a transaction to which the plaintiff and defendants both parties was ruled to be unaffected by the relevant land code provisions, and so the learned trial judge was proper in directing rectification. In the case of Land Case Berhad and another versus Overseas Credit Finance Berhad and others 1988, it is held that if a right in personam or an equitable rights exists prior to the registration of title to land, equitable principles of remedies may be used. In the case of Chu Akau and Yo Yutiam and another 1989, it is held that performance by one would discharge the other, and consequently, depending on the fact of each case, the principle of election would apply as provided by Section 179 Contract Act 1950. While in Tan On Ban versus Teo Kim Heng 2016, the Federal Court emphasized the principle of beneficial ownership, where it is said that the right of a purchaser who has not settled the full purchase price is contractual in nature and in personam. In short, a beneficial or equitable owner of a property stands in the same position as the legal owner in terms of enforcing proprietorship rights against the world at large. The only difference is that a beneficial owner is yet to be vested with the legal title. The judge in the case Muhammad Sobri Chiu bin Abdullah versus Syarikat Perumahan Negara Berhad and 2 others 2022 relied on the authority in the 2 previous cases in his judgment, where it is held that, on the ground that the making of the demand breaches trust and violated the SPA, I find the demand to be unlawful and invalid. Even though the remedy of equity acts in personam can be raised, the application is limited by the Malaysian law. It is shown in the case of G. Retina Sami versus Majlis Ugama Islam Pulau Pinang and others, 1993, where it is held that the plaintiff was not a bona fide purchaser without notice. The plaintiff's action to obtain an indefeasible title was not honest and unconscionable. The limitation can also be seen in the above case of Tan On Ban, where the judge mentioned the principle of beneficial ownership in determining the applicability of the Maxims, equity acts in personam. As a short conclusion, the maxim is not applicable in all situations. It is limited by certain conditions based on the facts of every case.
To be concluded, the maxims of equity have operated similarly to the statutory interpretation canons of construction, principles to which the court can refer when deciding on rules and their application. Case law is still important, but the precedent principle is much more adaptable, and maxims are important. Equitable remedies, by definition, operate against the defendant's person and are punishable by imprisonment for contempt. As previously discussed, equity could claim that it is not interfering with common law in this way. In effect, the court's decision was binding on the entire world, and equity intervened only against the individual defendant, who was prevented from enforcing his legal rights. Another feature of this principle is that equitable rights were not enforceable against everyone and could be defeated by the legitimate purchaser's interest. The in-personam nature of equity operation is important in the context of property and interests abroad. In general, English courts will not hear cases involving title to foreign land.